Good morning, everybody. How you doing today? Yeah, so today's gonna be a little different. I've actually had this for a couple of days and I've tried to make this video, I can't tell you how many times. So I'm gonna screw it up because that's all I keep doing to it, and just screwing it up and screwing it up and screwing it up. But we're going to struggle through it this time because I need to get this video out. I was given this judgment for a family court case. I was told to mention Democracy Fund or something. There we go, I mentioned it. I don't know what the hell I'm supposed to mention it for, but there you go. I mentioned it. Anyway, excuse me. So, anyway, this is a family court case, a judgment on a family court case. Oh, somebody's trying to back out of my driveway here. My son's visiting. So anyway, this is very, very important to read and see. You can see the date on there is the 22nd of February. Okay, that's the same day that Trudeau revoked the Emergencies Act. And see yes. And but this is the same day that this judge came up with his ruling. Basically what it is a father wanted to vaccinate two of the children. The mother did not want to vaccinate the children. Oh shoot. Oh well. So they went to court, and this is the judge's ruling. Now this is very, very important for us because it's showing the mindset is changing. If you remember when I left Ottawa, I said things have to go into a political and legal direction at this point, because it's no longer about the protests, it's about the politics and the legal side of things. One thing about law is, in order for things to change, they need to set precedent. And a precedent is judgment and the judge's reasons why they created that judgment. And that creates a precedent which will then trickle down into further cases that will come along. This one sets an incredible precedent because for once we're allowed to actually have an opinion. And not only are we allowed to have an opinion, but this judge shows his opinion on what is happening around the world right now. So let's get started into this. All right, I've been babbling long enough. I'm not going to read the whole thing because, oh my God, is this long. I will later on today. I will put a link to this in the description, but I can't do it from my phone. I'm not that techie. Anyway, so let's get into this a little bit here. All right. Just going to skip by there. The Honorable Mr. Justice A. Pazarats. Okay, I apologize if I butchered that name. But anyway, this is his judgment. 1. When did it become illegal to ask questions, especially in a courtroom? Very good question. But around the world, it is illegal to ask questions these days. And when did it become unfashionable for judges? Oh, thank you, my truck stopped. And when did it become unfashionable for judges to receive answers, especially when children's lives are at stake? How did we lower our guard and let the words unacceptable beliefs get paired together in a democracy on the scales of justice? Should judges sit back as the concept of judicial notice gets hijacked from the rule of evidence to a substitute for evidence? My phone is going nuts. I love this one. And is misinformation even a real word, or has it been a crass, self-serving tool to preempt scrutiny and discredit your opponent, to delegitimize questions and strategically avoid giving answers? Blanket denials are almost never acceptable in our adversarial system. Each party always has the onus to prove their case, and yet misinformation has crept into the court lexicon. A childish but sinister way of saying you're wrong and I don't even have to explain why you're wrong. This is a judge saying this. What does any of this have to do with family court? Sadly, these days, it has everything to do with family court. Because when society demonizes and punishes anyone who disagrees or even dares to ask really important questions, the resulting polarization, disrespect, and simmering anger can have devastating consequences for mothers, fathers, and children I deal with on a daily basis. It has become harder for family court judges to turn enemies into friends when the governments are so recklessly turning friends into enemies. That was you can tell that's a direct punch right at Justin Trudeau. The motion before me is typical and frightening example of how far we are drifting from the cherished values. The father wants 2 children to receive the COVID vaccine. The mother is opposed. Now, answer honestly. Did this paragraph give you enough information to form an opinion on how the case should turn out? We are all weary. We wish COVID would just go away. But pandemic fatigue is no excuse for shortcuts or lowering our standards. We have to guard against the unconscious bias of thinking, why won't these people just do what the government tells them to do? We have to decide on a basis of interest of each particular child in each particular fact situation. We have to rely on and insist upon evidence. A lot of people have been saying that for a long time, but we're not allowed to say that. In this case, the evidence provided more questions than answers. The father filed 2 affidavits, the mother 1. Both are relied extensively on unsworn exhibits, which were basically internet downloads. In addition, the father relied on numerous downloads from the mother's social media accounts. Both consented to my receiving these materials to demonstrate sources of information to which each of them relied on formulating their prospective parenting positions. The basic facts are not disputed. The mother da-da-da, the married da-da-da, da-da-da. I'm trying to skip that. I think this is where I start to skip ahead a little bit. You can pause and read this if you so desire, but I will be putting a link in this later on. I just want to make sure I get to the part where I'm trying to get to. The mother insists the father misrepresents her position. She is not opposed to vaccines. She's offered by pejorative term, anti-vaxxer. She has always ensured that 3 children received all of their regular immunizations. She says her open-minded vaccination, both younger children, is a safety concern that can be better addressed. But she says her extensive research has left her with well-founded concerns and potential benefit that the current vaccine is outweighed by the serious potential risk. She says there is too many unknowns, and she is worried that once the children are vaxxed, they can't be unvaxxed. Mother notes that both children have already had COVID, minimum symptoms, and have recovered completely. She refers to medical research, which says since they've already recovered from COVID, da-da-da. All right, let's get down here. The father's affidavits include the following. I'm aware the applicant has political affiliations with People's Party of Canada. I searched the applicant's Facebook postings and alarmed just how involved the applicant is portrayed COVID conspiracy theories and vaccine hesitancy. He attached a collection of some of the Facebook's postings, which I believe are indicative of personal views. Let's see here. Website. He makes other references to the mother's Facebook account and attaches numerous pictures. Where to begin? How is this relevant? Have we reached a stage where parental rights are going to be decided based on what political party you belong to? This is the judge again. Okay, we're back to the judge here. Is being seen with Maxine Bernier, or anyone for that matter, the kiss of death as far as your court case is concerned? Can you simply utter the words conspiracy theory and do a mic drop? If you allege that someone is openly promoting very dangerous belief, shouldn't you provide a few details? A bit of proof, maybe? And if you presume that the parent believes things that shouldn't be believed, can you go one step further and also presume that the parent must be poisoning their children's minds with these horrible unspecified beliefs? Surely these thoughts and feelings are also being promoted in their household? Excuse me. The father criticizes the mother for something she didn't say. He presumes she doubts the effectiveness of school closures, then criticizes her for providing no evidence. But on the same motion, she didn't raise the issue. And back in 2020, she was the one who wanted to keep the children out of school, and he fought unsuccessfully for them to attend. As with other allegations, the father provides no evidence of his own, fails to address the fact that the vigorous community debate led to the school closures being abandoned. How far are we willing to take guilt by association? If you visit a website, read a book, or attend a meeting, are you permanently tarnished by something someone else wrote or said? At what point do the thought police move in? And really, how fine is the line between vaccine hesitancy and not taking any chances with your kids? All the case law says judges have to act with the utmost caution and consider all relevant evidence to determine the best interests of the child. How can we then impose lesser standards on a demonstrably excellent parent? It is little consequences that the individual litigant chooses to advance such dubious and offensive arguments, even coffee, even though the father may not admit it. This is still free country. But there's a bigger problem here, an uglier problem. Thank you for the coffee.
You're welcome.
My neighbor bought me coffee. She's amazing.
I'm fucking awesome.
Say it again.
I'm fucking awesome.
Yes, you are. You too. We're seeing more and more of this type of intolerance, vilification, dismissiveness, character assassination in family court. Presumably, we're seeing it inside the courtroom because it's rampant outside of the courtroom. And it now appears to be socially acceptable to denounce, punish, banish anyone who disagrees with you. A chilling example, I recently had a case where a mother tried to cut off an equal time father's contact with the children, primarily because he was promoting anti-government beliefs. And in communist China, that request would likely have been granted. But this is Canada, and our told you I'm butchering this, system has an obligation to keep it Canada. I won't belabor the point because I still have to get to my real job, determining what best interests of the two children. But the word needs to get out that while the court system won't punish intolerance, it certainly won't reward it either. All parenting issues, including health issues, must be determined based upon the best interests of the child. Last year's amendments to the Divorce Act, mandatory that the courts include consideration of the child's views and preference. Okay, now we're going to get into some child stuff, so I want to skip way ahead here. Yeah, sorry, I need to find this again.
Doing your videos?
Yeah, I'm trying to get this video out. This is a long one because it's about a court document. I've been trying to do it. I've done it like 17 times.
17? Oh, is it because it's too long? Or?
Yeah, there's so much and I keep butchering it and you get into legal talks and I just like, blah. Sorry guys. I'll get to this part I wanted to see here. Actually, this video is carrying on quite long here. I might actually just speed things up along here. I want to get to the very bottom where he actually makes the declaration. He voted in favor of the mother who did not want to get the children vaxxed. So, and then he put in a post note. And I want to read this post note that he put in here. Postscript, there we go. It is irrelevant, my decision, and none of anyone's business. But I am fully vaccinated. My choice. I mention this because I am acutely aware how polarizing the world has become. We should all return to discussing the issues rather than making presumptions about one another. I am so impressed, and I'm gonna, like I said, I'm gonna put a link to this so you guys can read the whole thing for yourself, and then you can make your own decisions on what this has to do with everything. But for now, I would like to say to the Honorable Mr. Justice A. Pazarats, welcome to the Fringe.